Okay, so we've just finished talking about Locke v. Davey and about the Yoder case. I wanted to just touch back quickly on the issue of teaching religion in schools. So we gave this scenario in class about if I were a biology teacher instead of a civics teacher, and I said, students, today we're going to talk about the origin of life, and so please open your Bibles and to the chapter on Genesis. And we all understood pretty easily that that would be a violation of what clause? So what clause would it violate if I, as a public school teacher, taught you that the origin of life was happened as it stated in Genesis? What would that violate? Hopefully, you came up with the fact that that would violate the Establishment Clause. Congress shall make no law respecting an establishment of religion. Why? Because I, as a public school teacher, get your family's tax dollars. I receive public money, and that cannot be used to teach religion. That would entangle religion and the state too closely, therefore violating the Establishment Clause. All right, we went into a second scenario then called intelligent design, and this was a case that came before the courts. There was a group that wanted to have the theory of evolution taught in biology class, but as an alternative theory, they wanted to teach what they called intelligent design, which was the idea that the structures, the physical structures of life, were too complex to have been the result of random selection. And they wanted to teach this theory, saying that they had gone out and collected evidence, and the structure of the eye was one of the pieces of evidence that they used to prove that physical structures were too complex to have resulted from natural selection. So I asked you, thumbs up or thumbs down? Is that okay? Can a public school biology teacher say we're going to learn about the theory of evolution and we're going to learn about the theory of intelligent design? And as we've discussed in class, the courts have said no. A public school biology teacher cannot do that, so let's look at why. The courts said that fundamentally what the intelligent design community was doing is they were going out and collecting picking and choosing specific evidence that they believed supported their theory, and that fundamentally that is not science. So the court said what you may teach in science class are things that are accepted as science and are arrived at by virtue of the scientific method. You cannot teach something that is fundamentally faith-based. And that's what the courts held that the intelligent design community was trying to do. All right, so that's the scenario where we talked about the difference between the creationism and intelligent design, and that the courts have disallowed both of those under the Establishment Clause from being taught in public biology classes. Okay, we're going to talk now about the Barnett case. So in Barnett, a Jehovah's Witness was being asked to pledge the flag. And Jehovah's Witnesses, according to their religious beliefs, are not supposed to pledge oaths to symbols. So Barnett claimed that forcing him to pledge the flag violated his religious beliefs. All right, he sued. Let's talk about what was the did X violate Y. The legal issue presented was, did suspending Barnett for failing to pledge the flag based on his religious beliefs violate his free exercise rights? Now, the court held in Barnett for Barnett, essentially answering the question as yes. So here's what the court said. Barnett's the fact that Barnett did not want to pledge the flag, that arose from his religious beliefs. And the court upheld his argument that it would violate his free exercise rights to demand that he pledge the flag, even though his religion prohibited him from swearing an oath to a symbol. So the court upheld Barnett's argument that forcing him to pledge the flag and punishing him for not doing so violated his free exercise rights. There was a second point in Barnett, however, and that starts to get us into this free speech realm. So here's what the court said in Barnett. Even if Barnett had not been a Jehovah's Witness, so let's say he was just a student who did not follow any particular religious tradition, But the student said, I don't agree with the Pledge of Allegiance. I don't agree with the contents of the pledge, and I don't want to say it. There, clearly, it's not a free exercise issue raised. Instead, that is a free speech issue. So when it says Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, the First Amendment goes on to say, or abridging the freedom of speech or of the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. So the second issue addressed in Barnett was whether his free speech rights were violated by forcing him to say something that he did not agree with, which was the Pledge of Allegiance. Again, the court held for Barnett, holding this. The court said that the right of free speech includes the right not to be forced to say that which you don't believe. So the court held that Barnett could not be punished by the school for refusing to say the Pledge of Allegiance because forcing him to say something that he did not believe would violate his freedom of speech rights. All right, that launched us into Barnett. I wanted to quickly talk about the Tinker case. Tinker continues with the freedom of speech theme, but it does in the context of public schools. So in Tinker, the question was that some students were wearing black armbands, silently wearing black armbands. They weren't protesting, and yelling and carrying signs or anything. They wore those black armbands in protest of the Vietnam War, and they were disciplined. The question was, did disciplining Tinker for violating the school's prohibition against wearing black armbands in protest of the Vietnam War violate her free speech rights? And the court held that yes, Tinker's rights weren't violated. So let's walk through that quickly. We know that you have less free speech rights in the classroom than you have out on the street. We'll talk about that next video. But in the classroom, you still do have some free speech rights. And the court set the standard that a school can discipline a student for speech if that speech either disrupts the normal classroom activity in the class or if that speech stops and prevents the school from meting out discipline. So if speech is doing that, the school may suppress it. The school may not suppress speech that doesn't either disrupt the classroom or make it more difficult for the school to discipline its students. So the court held that Tinker was not disrupting the classroom, was not disrupting school discipline, and so the school had violated her freedom of speech rights in punishing her for wearing the armband. Okay, that is the Tinker case. The next video we'll talk about Snyder versus Phelps and the free speech rights out on the street and in public forums.